M-SPAN brings you long-form public affairs programming within Mayflower, made possible by our sponsors. M-SPAN, easy access to government matters.
Good morning, everyone, or good afternoon, good evening to wherever you guys are connecting from. I'm calling this press conference to address certain issues with the Clark County District Court. Specifically, we are addressing complaints in regards to the court's general operations in relation to the activity level of certain judges, including myself, as to the staffing issue that our court currently faces, backlogs, among other things, and certain other issues which I may not fully address just yet, but willing to mention. We also are intending on addressing certain deficiencies in our relationship with other executive departments, like the Department of Justice, and to establish our certain plans working with the District Attorney's Office for the county. and also a potential change in how people can participate in the judiciary in the future, both as attorneys and as judges. I would just like to make a quick announcement regarding two things. One is regarding the expression of interest form that the governor has released. This form is purely just to obtain an idea of how many people are interested in being a part of the court, and also a chance for people to express their general knowledge of the law, otherwise about fairness, and also to assess qualifications and capability in potentially being a member of the court. This was produced in coordination and with the combined effort of the Governor's Office. We've expressed that there is a need for competent judges and active judges who will be willing to take cases without much of an issue and not take long absences, which I understand that this court has been riddled with, and also a need to find competent judges not just within our own jurisdiction but also outside. Some will take note that for the district court judge qualifications, there is no specific qualification for people to be a member of the state bar. We have removed this, and the reason will not be disclosed, but in case anyone wishes to know why that is not included, it is to allow us to seek potential candidates outside of our jurisdiction as well. Not that they would be fully considered, but if they do provide exceptional ability, we are willing to make concessions in accordance with the law to either enable them a pathway into the judiciary or be full-time judges, given that they meet the statutory qualifications. Magistrate judges, on the other hand, have statutory qualifications, and for anyone applying for those positions, we would ask that you do retain those qualifications when you apply. And also another matter is in relation to the contempt finding that was given by Judge Ryan yesterday. I was, in fact, held in contempt of court and sentenced to 5 minutes, remanded to the Clark County Corrections. I have, at that time, been processed and was awaiting to fully begin service. I have sought counsel and have sought a stay on that sentence, and I was given that stay. So this time, I am in the process of appealing. I'm in the process of appealing my sentence and my contempt conviction with the Supreme Court. I will make full submissions, including my briefs in support of my position, and we'll be litigating this in the Supreme Court in the coming days and weeks. I would ask politely that the audience, as I can read your messages, to please not comment on how I speak or my appearance. This is just how I am, and if there are any trouble, you may freely ask for me to speak up. That would be appreciated. That's just another matter I want to get away from. That's sorry, just to address, in case there was any concern for that. If that message is okay. Join me in this press conference is my good friend, Mr. Blue Ahmed. He's one of our deputy clerks of court. He works for the Protonotari's office. I'm still having trouble saying that word. And also joining me is Miss Ashley Pueri. She's our clerk of court. She's been with us for quite some time now and is in charge of all of the general staff and the clerks of our court. She has graciously provided her services today as a moderator. This event is Rule 7 protected. We will politely ask that anyone intending on shooting up this press conference to not do that. They usually ban people for a day if they do it. It would not be in anyone's moderation, in anyone's interest in having their moderation record tainted over a silly shooting at a press conference. To the other moderator here, we thank you for being here. Ashley Prairie is providing protection for this event. She is providing Rule 7 protection. Several things I intend to address are about the operations of the court, about the activities of judges, about the way we handle business in the court, the way we handle trials, and also our future plans with regards to staffing, general court operations, and how attorneys will function in the court going forward. I have been in extensive consultation with the Supreme Court, namely the several justices and the Chief Justice, about how we could better improve our operations down here. I will admit that the District Court has had a lot of trouble in recent times. Over the past few months, we've experienced an immense backlog, which we have failed to recover from for quite some time now. We've recently employed Blue Ahmed and several other staff to help alleviate that backlog, but we have once again come across the backlog issue again after resolving it for a brief period. We have intentions to fix this, and we have intentions to deliver justice, to administer justice very fairly and swiftly. We have no intentions of having to make people wait for months on a decision. It is given under our own rules that we would normally rule and finish all of our cases within a set period. It's given us 20 days. It is an unrealistic number, considering our current situation, and may not be for the case, but we try to aim within around that time. I have collected the data and can confirm that on average our cases usually take between 1 and 2 months to finish. Some cases have now gone as long as 4 to 5 months. This was not as common back then, around August, sometime last year, where I presided over a case that lasted 4 months, and that was the longest ever. Cases usually get disposed in about 3 weeks back then. We've now had a significant change in that. We are currently working on plans to address those, and hopefully we will see to it that cases no longer take 1 month for resolution, if at all. Several issues arise as a result of the delay in decisions and the backlog. One of them, admittedly, is our judges, including myself. We have taken a rather long amount of time to come to a decision on certain issues, which ordinarily would take about not even less than a week or within a few days. I would find that this is unacceptable. People are bringing in cases for a swift resolution for situations that frankly do not deserve a month long to decide on, can take much shorter times. But it seems that upon assessment it is both a matter of our availability and our own pleasure to determine when we make a ruling on certain issues in a case. Some have also had issues in relation regarding getting in contact with the court to be able to either relitigate otherwise re-participate in a case, and that there is literally little to no established procedure put in place as to how both attorneys and members of the public can get in contact with the court other than through direct messages. Our staff can get lost in the amount of messages that they receive on a daily basis, and in that we believe that it is no longer efficient for us to have our current process in place where people just message our staff and hope things work out. A lot of confusion has arisen as a result of our current process, and we intend to address that preferably within the coming weeks. Judges have been inactive for good reason on some of them, and for some for no good reason. Some are on holiday, some are not, some have medical emergency, some don't. Some have chosen not to give a reason at all and still take leave. Efforts were made to ensure that judges would inform my office about the reasons why they take leave of absence, and some have responded, some have not. It is rather unfortunate that that is the current situation. I do admit that it has been quite troubling, at least from my perspective, and that I was not able to really take control or manage effectively the timetabling of our judges' schedules. As a result, many people have suffered when they're involved in the cases. A lot of reassignments had to be done, given to active judges so that the cases can be resolved. We believe that this is no longer acceptable and it must end. So I am making a public pleading to all of our current judges, in which I have very limited powers upon, that they need to take action. They need to be able to address the cases with regards to making decisions in a timely manner. It should not take 2 months to decide on a case. Excuses can only be made only so as far as to being reasonable. At some point, it can no longer be reasonable, and decisions will have to be made. I have already had an issue with regards to one judge, who is now subject to disciplinary proceedings under Canon 3 of the Code for Judicial Conduct, and that they have had 16 cases in which they failed to adjudicate effectively and within time, and they've used foul language to principal staff. I will not name that judge specifically, but the public record will show who it is. I intend to address this issue by having to inform all judges that should they not provide any excuse or any reasonable excuse for the delay in them deciding on the cases, or they fail to provide any reason for the leave of absences, which is beyond 5 days, that I will refer them to the Supreme Court for disciplinary proceedings. The penalties that may result if they were to be in breach of any rule in the Code of Judicial Conduct may amount to suspension or exclusion from the bench, otherwise permanent reassignment to another judicial district. The public does not deserve inactive judges, it deserves competent and active judges. I have done much I can to try to resolve it quietly, but I can no longer do that in light of the many issues that we face. I now make a public apology to the residents of the state, to members of the Department of Justice, to our attorneys, and to all those who participate in our judicial system of this excessive delay in justice being administered, and that I should be held wholly accountable for the way that things have been in the past few months. I will not be surprised, and in fact, in the upcoming election do invite for any scrutiny by the state legislature and to any other bodies to which I am answerable to in regards to the operations of the court. I will also not be surprised in any complaints being lodged against me specifically in relation to how I have handled the affairs of the court as well. I take full accountability for how things have been for the past few months. I do apologize. This is a moment for us to change, and this is a moment for us to be able to address a lot of the issues. The reforms that I propose will be significant, and they will take time to implement. The changes will not be immediate, but they will be apparent within due course. I specifically have proposed a new measure to the local rules in relation to how we conduct trials. Engagement with cases have been rather poor. The quality of it especially has been poor. I have taken notice of one case specifically in which a trial is being held asynchronously, where attorneys and the court have had trouble keeping track and understanding the finer details of the case, which is essential to the aspect of a fair trial. Everyone partaking in it should have a meticulous knowledge and understanding and should be paying full attention to the details of the case, especially for attorneys who are making representations on behalf of their client and for the court, so that it may render fair and accurate decisions. I find this to be both not only a risk in litigation, but also a risk to the integrity of the entire district court and to our judiciary. The local rule will propose that from now on, any case that proceeds to trial is to be held synchronously in session and in game, and that asynchronous trials being held over Discord should be rarely used and only permitted under reasonable circumstances. It can be requested by an individual attorney with the permission of court, or moved by both parties without the permission of court. Every measure should be taken so that an in-game synchronous trial can take place, including a rescheduling of the trial if there is a scheduling conflict between attorneys and the court or any of the clients. While attorneys may argue that it is out of convenience, but also out of expediency, that trials be held over Discord, and that it is accessible to a lot more people if it were to be held over Discord primarily, I argue that that is not, in fact, good enough. Trials should be held in-game, live, where everyone can participate and also observe and scrutinize the judiciary and how it handles its business. And also to give an opportunity for the defendant, in any situation, to be perceived and observed by his peers and members of the public in a fair and neutral place. The attention span of many people in the case can be varied. Not everyone has an equal attention span, but everyone who will be participating in endgame trial will always have a meticulous understanding and a live attention, strong live attention to the details of the case. And that, if that were to be the case, the defendant can confidently say that they had a fair trial, and that any decision that was made by the court would be rendered fair in the eyes of the law. Providing primary Discord trials is no longer acceptable in my eyes, and in my opinion, should be rendered unfair unless the circumstances warrant the need for it. In addition to this, we want to also make the courts a lot more accessible. Recent laws passed, including a new offense being created for stalking, both in the criminal respect and in the civil respect, and I intend to open up a new way for people to be able to litigate certain matters in court. Specifically with regards to stalking offences, I intend to allow for people, without having to rely on an attorney, to file cases in court, where they may ask the court to give them a temporary restraining order against any person who is engaging in stalking, and to be able to argue their position before a judge, eventually also with the respondent, in a very neutral and fair manner, without having to file any technically strenuous paperwork, and to make it more accessible overall in that process. A lot of people have come to me before complaining that the court's inaccessible, that it has to rely on attorneys for a lot of the paper. Oh, jeez. Jesus Christ. Sorry, everyone. I don't know what happened there, other than someone dying. Unfortunately, we will not have a moment of silence for this occasion, but we will address that after the press conference. Anyhow, people have complained that the courts are very inaccessible, that it has to rely on attorneys, because of the fact that there's a lot of paperwork being involved, requiring technically sensitive and that it requires a lot of technical language, which not everyone can understand. Only trained eyes can. And because of that, they feel that they're not receiving justice, or having an opportunity to be receiving justice. So I intend to address that at least first by fully establishing the statutory procedure outlined for stalking. The statutory procedure for receiving a temporary restraining order outlined in state law. This should come into effect in the next few weeks. I have already prepared the forms and intend to propose this to Supreme Court for approval, for a change of the rules. Before that, I will also consult with the judges as to any improvements needed for that, and have their consent before I submit these proposals. Among other things, the way that the state bar will work is also changing. I can confidently say that there have been new appointments made to the state bar, specifically 2 justices of the Supreme Court, who intend to address the deficiency in both the legal knowledge that junior attorneys possess and to the way that law is practiced in this jurisdiction, and to the way that attorneys are admitted. Discussions are currently ongoing as to how we would be able to make the legal system a lot more accessible and to allow people to be able to qualify as attorneys a lot easier, a lot more simpler. Discussions about the bar exam being reformed, introduction of new schemes, including apprenticeships, are being discussed. Opportunities to be able to have hands-on experience with senior attorneys at law firms and other approved scheme providers are also being discussed as well. Full details about that will be announced by the State Bar in due course. We intend to address the performance of our attorneys also effectively, and to allow for a more fun, interactive, and I hate to admit this, but also dramatic experience that makes rule law quite attractive to a lot of people. In relation to the staffing operations of the court, we have had numerous issues where we've had trouble finding and identifying certain members of staff belonging to which judge and what their purpose might really be in court. I'm currently working with Blue Ahmed and Ashley and our staff attorney and other members of the on Terry's office to identify who among our staff are actually employed with the court, and to set up a formal employment scheme for those who wish to partake in the court's business in the future. We expect to hire new people in the future to take part in the court's work. We also intend to open a research law clerk position. An allowance of up to 2 being given to every judge of the court to allow for any person who wishes to become an attorney or any qualified attorney to get hands-on experience working on the other side of the bench, the other side of the bar of the court, and understand how the bench works, in the hopes that they can one day become a member of this court as a judge as well. Deficiencies are also noted as to the backlog. The reason for that is because a lot of us have taken leaves of absences for personal reasons and also for statutory set annual leave being also put up and booked in. Yes, we do have a certain amount of days being given to us for us to take a break and come back fresh. It's not really unusual in these kinds of systems. So we do apologize for that backlog, but we are intending to address it as soon as possible. I'm open to questions, both in-game and also in the general chat. If you would like to be able to ask a question, you can do it in either methods. I'll invite Mr. Lusolab to give instructions on that. I think Mr. Lusolab's having some trouble right now with his microphone. Stand by, please.
Okay, hi everyone. This is Luso. I am with MSpan today, so we will be taking questions for Chief Judge Albert Wellesley. So just ping him in general chat, and just ask your questions there. He'll answer it as freely as he wants. Troll questions will be disregarded. Thank you.
Okay, I'll take questions. I can also receive them in-game, but if I do not respond to your question in-game, then just keep repeating those questions. I'll be having 2 monitors in place to see what's going on. If it will work on my end, I'm sorry. I will not be taking questions over DMs. I do apologize. I do have a lot to go through, so I will not be able to read your questions in DMs. You may ask them in-game, or alternatively you can ask them in general by pinging me. Hello, Martha. Hello, Orange Bear. Toby asked, why is it taking the SCOM so long to reform the bar? This is something that I cannot comment on. It is kind of actually out of my own purview. I have no control over how the state bar works. I can only give input as to what other judges have suggested, and as to what needs to improve from my own opinion. But beyond that, I have no control over that, so I can't answer the question any further. Orange raised a question, but has raised no question. Mechanicalize has raised a question. Can you have judges actually reply when denying search warrant or arrest warrant affidavits of probable cause? There isn't any way to figure out what the issue is when they're wordlessly denied. There's a particular reason why we do not really inform officers as to why a search warrant or an arrest warrant request has been denied. We do receive a lot of these, and we do have judges on the clock routinely looking at these. Average time to answer these requests is about 6 hours. we also have to balance our own cases as well. We do deny quite a lot of them because they do not establish probable cause, and as that's the only simple reason why. An announcement was made that that if a particular warrant has not been issued, the assumption should be made that it has been denied. And in that case, that's the kind of reason why we would not do it. But I am open to considering a way for us to be able to communicate better with law enforcement as to the status of their warrants, because I understand that it is quite deficient, and that we should perhaps address this in a later matter. I do appreciate Mechanical Eyes raising that question, and I will be seeking potential solutions to that in the future. SDS, what will you do about the criminal gangs? It is not my job to really address the issue of criminal gangs, other than if they appear in my court and they've been tried for offences. It is on the Department of Justice and the District Attorney in the future to prosecute them, and the police to investigate and otherwise charge them, but it is not for me to decide on that, I'm afraid. Orange Bear asks if I'm okay mentally. Yes, I am. Toby rules for DMs, no. Adam Sherman asks, what do you plan to change in the courts to ensure the cases don't take 300 years to complete? This is a good question, I was expecting this. So, it's still kind of in the works right now, but I'm planning on changing up how dockets work. At the moment we have a situation where we only have one giant docket where all the cases come through, and it gets shifted to the individual judges. I plan on making separate individual dockets that is categorized into certain into levels of urgency and expedience and the division of the case. If there is a case such as a civil emergency petition for whatever, that will be put in the emergency docket and they'll be read by a judge within a reasonable amount of time, preferably within the hour. For civil and criminal division cases, those will be handled individually by the judges still, but they will be assigned to separate dockets, like a criminal emergency or a civil emergency docket, which will be read by a specific judge on that day. Those will be handled likely by magistrates. Among other things, we'll have a dedicated docket to warrants and other special matters, like any temporary restraining order for stalking. It is still in the plans. It is not refined. It is something they came up with only about a week ago, and we're still working out how to make that logistically possible. I will be talking to several people and how I could do that. So I appreciate that this is not a full, complete answer, but I intend on addressing that by having to do what I just outlined. Toby asks, what are you going to do about judges on constant LOA? Under the rules at the moment that I put in place, any judge who takes longer than 5 days will have to give a reason why they have to go on LOA. And if they take an unauthorized LOA, they will likely have the dockets closed and suspended. And if they fail to provide any reason after the intended return from LOA, then they will have the dockets essentially indefinitely suspended and reassigned. And that will be only if the cases took 2 months, for instance. And obviously you cannot wait any longer than 2 months. It's just a kind of general arbitrary idea. I'm not entirely sure how I could fully address it, but that's kind of my thoughts as to how I could. They would have the permissions essentially limited and revoked until they can come back. I will have to promote a lot more effective communication with the judges, but there is very little I could do in the judge's ability to take over cases other than what had been given as a power under the rules. But if they do have to take longer than 5 days of leave of absence, they will have to inform me of the reason so that I could be insured. Otherwise, 1 second. Sorry about that. Yeah, so I plan on having to address that issue by forcing judges to give LOA reasons from now on. I would log it, otherwise I'll be facing various penalties. Judicial complaint will also not be out of the question. Ramsey asks, can I be a judge? You should apply. We have the forms available in the Gov announcements. A lot more question by mentality. Scapetti asks, what about you automatically give default if no response is given? So that's in the rules. Unfortunately, I can't really change that unless the Supreme Court does, so that's something I can't really do. But I have instructed members of our staff to be able to address this effectively, and that we're trying to figure out a way to be able to allow attorneys to come in contact with the court and inform us about cases defaulting so that the clerk can essentially enter a default on our behalf on the same day or at least the next day and note the default. We have noticed that judges have been relied on to actually file the defaults, and that has proven ineffective, so we'll be utilizing our staff from this point onwards to do that. Martha Sams asks, is the court's backlog a mental health related crisis because judges are tired of retard? I won't be answering. Sorry, I won't be. That's a pretty strong word. I won't actually say that on public television. But the backlog is created for many reasons. Judges have individual reasons as to why they cannot deal with cases in an effective time. But it could also be related to mental health as well. We have had situations like that, and in that case I will not elaborate further, but I have given permission for them to take a leave of absence if they had a mental health crisis, and would assign the cases to someone else who can deal with it, otherwise have them deal with talk to another judge to be able to have the cases assigned to them instead, among other things. It could also backlogs have also been created because judges have simply just disappeared out of nowhere. And we intend to address that, obviously. Albert asks, will the state bar give me a bar cert? Hopefully the way that we do that will be changed and it'll be much easier for you. I know that you have been wanting to get that for quite some time. We should speak to the state bar about that. On behalf of SciPac, Krabs asks, the governor issued Executive Order 8302 to combat discriminatory economic boycotts against the State of Israel, among other things. Will the courts be complying with any provisions of this order, and if so, to what extent? I'd like to emphasize that the Executive Order does not impact the judiciary. We're a separate branch of government. We're not accountable to the governor, unlike the members of the Executive Department, who are currently and under the direct control of the governor, save for certain exceptions like certain department heads and local county police, local county and municipal police. We do not intend on complying with this executive order unless the Supreme Court has explicitly instructed us to do so by adopting its own policy in relation to this, although I'd argue that would not likely be the case. Although SciPac has benefited with providing good support and donating to the good cause of the judiciary, we do appreciate the generous charitable donations and the pro bono efforts in helping us shape the judiciary to what it is now, and to help improve the judiciary to what is going to be in the future. But we have no intentions of complying with the executive order today. Ontario asks, on behalf of MPBS, the Clark County Court's website established a few months back. For the sake of easy access, will this still be used or will we return to Discord processing? We intend to use the website as is. We have no intentions of deviating away from the website. We would ask that people get used to using the website a little more. Dedan asks if I am gay. I will not be answering that question. Ramsey asks, the governor issued... Never mind, it's the same question. A lot of these questions have been repeated, so I'll just keep scrolling down to find a new one. Matt Kozinski asks if I can twerk for people. No, I will not do that. I'm just scrolling down the list. I've already answered that question. Do you guys think anyone's ever gooned in a Mr. Beast 100-day challenge? No. I don't know, actually. I don't really watch him. Robert Rosenfeld asks, will people continue to experience waiting a month to get a court ruling on the judge Olsen plays, or is they allowed to keep tracking on a ruling? No. And I have been in extensive contact with Judge Plays for quite some time in relation to his delay in the ruling that he has to make. I have given the benefit of the doubt, and I have warned him that his delay can amount to a potential judicial complaint, or otherwise some other action, but he has given me good reason as to why he's taking a long time. I have no intentions of having to submit any complaint yet to him, and I'm giving him the benefit of the doubt still. I am currently working with him to address the issue with regards to his cases and to his capacity to do his job, but beyond that I can't comment any further. Am I goy? I won't answer the question. Accepting or denying pieces. Mechanical is asked, in regards to accepting or denying AOPC, you said there are reasons why no reasons for denial is given. What are those reasons? In the past, judges held short 10-20 minute Discord hearings to deliver reasons for denial. Why is it no longer the case? It was always an option for judges to hold hearings for those, but it is not common practice. Most of the time, we are required by law to only consider what is in the four corners of the affidavit. So if we go beyond that, it would essentially amount to the warrant being void. So we can't really consider anything beyond that. Hearings were held most likely so that they could receive any further information that is in the affidavit but need more elaboration on. Only to the extent that they're allowed to consider, because they can't consider any outside information that is not mentioned in the affidavit. So these would be just to clarify things. But those are the reasons why such hearings would likely have been held. Otherwise, it's not common practice for us to hold hearings for these kinds of things at all. There have been cases where judges have also accepted affidavit requests over Discord. They've accepted it by having to, under the guise of it being a sealed warrant request, or that needs to be urgent, and they cannot wait. That practice is currently being reviewed. Whether that is lawful is another question, and whether it is practical is also another question. But I can't really comment much further on that specifically, but this was never accepted practice. It was purely discretionary thing that judges have done in the past. I have discouraged this practice as of recently. Dragon asks, I'm not going to answer that question. Naughty asks, will you be my girlfriend? I will not answer that question. Thoughts on EO80402? I am not allowed to publicly comment on any of these things, so I will refrain from answering that question. I am not an agent of the UN, I can confidently say that. Why do some courses still go on going after 6 months? There is no excuse for why cases should go on for that long. They shouldn't have ever been going on for that long. I have no clue why. But the responsibility is on the individual judges. Attorneys should know how to proceed in such a case where the case has been delayed for so long. But if I could think of any reason why it's allowed to go on for that long, it's only because of scheduling issues, and that will be on the part of the court or the attorney. There is a need for the attorneys and the court to work together to resolve scheduling conflicts, which can arise quite often in these cases. The state bar planning on making the bar exam shorter, yes. I think there is discussions that are happening. I can't confidently say whether that will be happening though, but there are discussions in place and there has been some positive momentum. Please make the bar examination easier so people didn't pass as VAB can pass this. There are discussions about making the bar, in terms of its content, also simpler, but which actually tests what you will need to be able to effectively litigate or otherwise represent people in court. Zero as can we go by Trello and Discord instead of website? I do appreciate that some attorneys do miss the Trello system, but we've had recent problems with it. They've limited the amount of people that could be a part of that board. If we want a full team there, frankly, we're going to need to either pay for that or otherwise advocate for the Trello team to remove the 10 limit collaboration requirement. So if that's not the case, we're unlikely going to be able to go back to Trello. And further, there are a lot of cards and cases, and having to store them, back them up, and load all of that at the same time does cause a lot of performance issues. That has been rendered impractical in the recent months, and so the website was used more often. We would like to still get used to how the website works and still make improvements to it. Feedback on how the website should work can be submitted directly into my DMs. I'm happy to forward these to the web admin. If one were to be hired through the form and they didn't know much about court proceedings, would your associates teach that individual? Yes, we will. So I have made it clear, at least to the governor's office and to everyone involved, that judges should be understanding of the law. They should know how the law works. They should have top legal acumen. But the general and principal idea of what a judge should be is someone who can decide things fairly, accurately, and also with regards to the rights of both parties, and without having to not only violate their own rules, but also be of sound mind and ethic. If they don't have a particular legal qualification, but they show absolute promise and they could do well in that job, I will make exceptions and allow for that. Allow for judges to be able to be trained in their art and potentially qualify. Whether the governor accepts such nominations without a legal qualification is another question, and that is entirely up to the governor by his constitutional prerogative. But if the opportunity were to arise, we would be happy to teach. At least I would personally. I'm currently in the process of doing that as well with one of them. Not for a judgeship, but I have a research clerk in place. I'm not sure entirely what court case that is. I would be appreciated if I could be referred to that case. Be my friend 1832. Lander asks, can I be a judge? You should apply if you wish to be. Crab says that I'm anti-Semitic. I am not. I love the Jewish people. I love every person. I have no hatred towards anyone. I have no opinion of anyone. And I will not make further comment on my personal preferences or friendships or whatnot. Am I part of the district attorney's office in real life? No, I am not a prosecutor in real life. Robert, I have not ignored your question. Thoughts on Korea and Israel separately. They are both great countries in their own respects. I love incompetent attorneys and makes court cases more dramatic. By our clerk. These are troll comments, do not take them seriously. Bob asks, can you make logging into the website a bit easier so I don't have to verify my account every time, especially well-known government attorneys? So this is a problem with regards to the platform. This is not something that we can control. I'll refer Bob to the Stafford County Railway website, for instance, where everyone who logs into that website has to verify every time. This is not something that we can essentially control. It is up to the platform to determine that. Unless I'm wrong, but I believe that's the case. I'm so sorry, Bob. It's for your own good. In case your account gets hacked, who knows, something bad could happen. We released a Carl Island flight log list. I have no access to that list. I have no idea what you're talking about. Mazda says he's a judge now. I can't confirm he's not. Make a law that is 50% times income of the people with the IDF. I have no idea why this mentioned. Can can Leo submit AOPCs that are denied receive feedback? I think this is a pretty pressing matter. In that case, I will discuss with the SC to determine whether we might need to change the rules to force that, or otherwise, I'll decide whether we should have a local rule put in place so that judges will be required to disclose those reasons. We do have a similar obligation for the SAs to be able to disclose their reasons for rejecting and filing charges, but that has not come into effect just yet. Hello, mate. Don't ask. Can I? No, please don't do that. Are you excited for the Wicked release? Sorry, release of Wicked for Good this November 21st. Yes, Kayla, I am. Mechanical Eyes believes I didn't answer the question, so I will read the question again for the third time because you didn't answer the question. You keep saying there are reasons judges don't or can't provide a denial reason. What are those reasons? So there's no particular concrete reason other than the fact that judges have to deal with a lot of matters. It is simply impractical for us to be able to contact each person every time we review the affidavits and then tell them the particular reasons why we've denied it. And in fact, the only reason why it would be denied is because there is no probable cause. There is simply no other reason why it would be denied. There are exceptions, though. Some other reasons could be that it violates game rules. We have seen people submit affidavits which can be, provide evidence, supplemental evidence, that would be considered NLR, and so we were rejected on grounds of it violating game rules. We may consider, in fact, disclosing those reasons and taking the time to tell those reasons, but it's just simply impractical for us to do it. Although we are happy to consider options where we might have a rule where we may be required to disclose certain reasons. Elemento says, can I crush you? No. Thoughts on the UK Online Safety Act? I will not comment on actual legislation. Can we be DL? No. Dragon asks, do you goon sometimes? I will not answer that question. Elemate asks, can we be in a secret relationship? No. I will not do that. Okay, these are just unrelated questions. I will not answer some of these questions. Which Korea did you refer to as a great country? South Korea. I think I have a slight bias on that. I have answered yes to Kayla's question about Wicked. What kind of car do you drive? Will not disclose that. Martha typed me for no reason. Oh, never mind. He's appointed magistrate judge. Okay, well I guess that's wrong. Do you support judges being law enforcement officers and do you see a COI? I would not answer that question. Yes, thank you, Zero. I do appreciate that. How much money for you to work on me? No, will not answer that question. Thoughts? That is a clip. I don't have time for that right now. My favorite day of the week? My favorite day of the week is Thursday. Bob asking about the new World of the War of the Worlds movie. I'm not even sure about what the movie is. I'll have a look and probably come back to answering that. Can you blow your nose? Someone thinks that I have some congestion problems. I don't. I just have a throat problem today. How old am I? Will not answer that question. You sound really out of breath. What's your mild time? I would appreciate not being asked whether I'm fat. So I won't intend any more questions from you. Thoughts on my puppy? I love your puppy, be my friend, 1832. Low, can we go out? Okay, Lauren says, do you support the alleged secret games hosted each year on a secret island in South Korea where 455 people die, given that you refer to it as a great country? South Korea has a lot of problems as a country. Its institutions can be corrupt, or at least is vulnerable to corruption. But otherwise it's quite watertight. And as to the island, I have no idea what you're talking about. I've been told to ask check DMs. May wait while I answer that question. One moment. I believe I'm also out of time soon. To wrap up instead, I will no longer take any more questions. I believe I've answered every question imaginable. I will release a statement made by our deputy clerk, Blue Ahmed. This is being read on behalf of him, and it reads as follows. I want to begin by apologizing for not being present in person. I truly wish I could have addressed you face to face. We do appreciate that Blue Ahmed is currently not here at this time. No. That said, I appreciate the opportunity to speak following the announcements made just moments ago, and I want to take a moment to speak directly, honestly. Not just as the Honorary Office, but as someone who genuinely cares about the state of our state courts. The truth is, the court has been under pressure, we've seen a noticeable increase in backlog, and the weight of that has been felt across the board. Our system has been strained, and delays have grown longer than they should be. I've been in constant communication with Albert, myself, that being, and other members of the courts behind the scenes. We spent countless of days in discussion, not only identifying the gaps, but actively working on sustainable fixes. These have not been surface level talks. They've been honest, at times difficult, but always focused on one goal: restoring the court's efficiency and reputation. It's why I fully support and have been involved in the reform efforts led by the central team. That central team is a reference to the Honorary's office. These changes aren't just administrative, but they are necessary. They're the result of weeks of planning, dialogue, and accountability. I genuinely believe this reform will not only tackle the backlog head-on, but also breathe life into our particular office. New faces, fresh energy, and renewed standards is what we are aiming for. As a member of this particular office, I remain committed to pushing for transparency, structure, and above all, service. And this office means a lot to me, and to see it move forward with purpose and momentum is something I stand behind fully. I appreciate everyone who continues to show up, ask the hard questions, and stay engaged. There's work to be done, but we are doing it. Signed by Blue Ahmed. So I do appreciate Blue Ahmed's remarks there. It is strongly appreciated and does express my views as well. So hopefully we'll get to address this as soon as possible. If there are any further questions in relation to what's been discussed today or regarding myself or any part of the judges, at this time you may ask those questions directly to members of our Honorary's office. You can find them over on our Discord.
MSPAN brings you long-form public affairs programming within Mayflower, made possible by our sponsors. MSPAN, easy access to government matters.